most common type of adult guardianship in New York State is a guardianship pursuant to Mental Hygiene Law, Article 81. In this type of guardianship, it is often a proceeding that is brought because somebody is unable to manage their own financial affairs or unable to handle their own medical affairs. Any form of cognitive decline can be the underlying reason for someone losing their ability to handle their own affairs, but very often we're looking at someone who's suffering from some form of dementia or a traumatic brain injury or other illness that leads to this loss of ability to manage these affairs. Managing your own affairs means paying your bills, managing your assets, keeping up your household, and can also extend to personal things such as speaking with doctors, making decisions about medical treatments, and other such matters. Having a proper estate plan in place can often be a defense to a guardianship. Because if somebody does have a cognitive decline and they're not able to pay their own bills or talk to the doctors or do anything like that, if they have a proper power of attorney, healthcare proxy, and other documents in place, then the guardianship is not necessary. Guardianship calls for what we say is the least restrictive alternative. So if the least restrictive is for the person who is being named as power of attorney and the person who is named as healthcare agent to step up and take that responsibility, then the courts don't need to get involved. Now, of course, there are cases where someone who serves as power of attorney either won't act or is unable to act, or in the worst case scenarios is acting improperly. They're misusing funds, not doing what they need to do, and same with a healthcare proxy. Then in those cases, a guardianship might still be necessary to appoint someone else to act, or also to remove that person who isn't doing something proper. If it's found that a power of attorney is misusing the funds, stealing the funds, then the court can also take action to have those funds returned. In the context of an Article 81 guardianship, it is not a medical determination. In fact, in order to look at medical records, there needs to be special permissions from the court. Instead, we look at somebody's functional limitations. What can they not do on their own? Is there some other mechanism in place to take care of that for them legally? And would that individual suffer harm if that wasn't taken care of? And this is how we determine if a guardian is needed. Now, guardianship is not meant for someone who's just making bad decisions. If there is someone who can't handle their finances just because they're not good with money, or someone who chooses to be addicted to a substance, legal or illegal, these are not circumstances that the court will step into with a guardianship. However, if that inability is because that person has a mental incapacity to handle something and they're unable to understand that incapacity, then a guardian might be appropriate. Each time a guardian is appointed by the court, that guardian will have the powers that the court specifically gives to them. Because guardianship is meant to be the least restrictive alternative, the idea is that the court will only award the powers that are necessary in that situation. A guardian can be appointed for a limited period of time or for an infinite duration. So in certain situations, a guardian is only needed to handle a certain task that is time limited, and maybe after 6 months or a year, that guardian isn't needed anymore. And in that circumstance, the court will usually appoint that guardian for that limited period of time. In cases where the guardian is appointed for an indefinite duration, again, the guardian is only given the powers that are needed in that circumstance. Most of the time, guardians are limited to either personal needs or property management powers. Some guardians are given both sets of powers. The personal needs powers are powers regarding somebody's medical care and how they are to be maintained, perhaps in their home or in a facility setting. whereas a property management guardian is handling the financial needs of someone, making sure that their bills are paid, determining what contracts should be signed, if they have a business, making sure the business is being maintained or the business is being closed down properly, and whatever other financial needs that individual has. While the personal and the property management guardian don't have to be the same person, they can be. The person who brings a guardianship proceeding, commences it, is called the petitioner. Now, this can be anyone who is fearful that an individual is going to find harm because they cannot handle their own affairs. Very often, it's a family member or a friend who brings the guardianship, although in certain circumstances, it might be the hospital or nursing facility that the individual is in, or it might be a local community organization that's concerned about this individual's well-being. Once a guardianship is commenced, a court evaluator is appointed. This is an attorney who is what we call the eyes and ears of the court. This person conducts an investigation, talking to the petitioner, the person who commenced the guardianship, talking to the subject of the guardianship, the person that we believe is incapacitated. We call them the AIP, alleged incapacitated person, and any other friends, family, or individuals that might have information that could help determine if this person needs a guardian, who the guardian should be, and what powers that guardian should have. One of the first inquiries that the court evaluator will look into is whether or not the AIP, alleged incapacitated person, is contesting the guardianship. Do they agree with the guardianship, or are they expressing anger that the guardianship was brought against them and seeking to put on their own evidence as to why they don't need a guardian? Some courts will appoint an attorney right off the bat to represent the alleged incapacitated person so that their wishes can be known. And other courts will wait until the court evaluator does this initial investigation and tells the court if an attorney should be appointed for the individual. A guardianship can also be contested by other friends and family members. So while one person may commence the guardianship, other family members or individuals may bring what's called a cross petition. They may seek to be appointed guardian themselves or state that the individual doesn't need a guardian. Consulting with an attorney to determine whether to commence a guardianship proceeding or not is incredibly important. Because while we all have concern for family members, and we might see a situation where there's a family member who could use some assistance, that doesn't mean that it rises to the legal standards in which a court will appoint a guardian. Bringing a guardianship proceeding and having the court determine that a guardian is not necessary can be very costly. You have your own costs of commencing the guardianship, and then also the costs of court appointees, such as the court evaluator. Determining whether or not you have the information to meet the legal burden to show that a guardian is necessary should be discussed and evaluated by an attorney who is well versed in this area and understands what the potential downsides could be. The attorneys at Burner Prudenti Law know the courts and understand the law involved in a guardianship proceeding. We want to help you evaluate what you're looking to accomplish for your loved one and make sure that guardianship is the right avenue to pursue.